good morning, good afternoon, and happy holidays to in-house counsel from all across North America and the world. Welcome to a special Rumble in the Redlines edition of In-House Connect. My name is Shai Mahani. I'm the CEO and co-founder of In-House Connect, and I'm thrilled to have you here with us today. Thank you for spending your breakfast time or your lunch time with us, and special thanks to our wonderful sponsor, Lexion, and our fantastic presenters today, Jessica Nguyen and Daniel Chen, who are coming on to battle it out in the Redlines on today's program. This is our 66th event of the year, and I'm wondering, have you attended an In-House Connect event in the past, or have you been with us before? Looks like we have a 55-45 split, 45% new and 55% returning. So welcome to the 45% and welcome back to the 55%. And I want to give a shout out to the 20% of people who have attended more than 5 In-House Connect events. We love you. Thank you for making this year so special for us. All right, no more housekeeping announcements. We have an amazing event today. Rumble in the Redlines, how to redline and negotiate DPAs for in-house counsel. And I have to do my best Michael Buffer impression. So here we go. Ladies and gentlemen, in-house counsel of all ages, let's get ready to redline. All right, introducing outside counsel for big tech, standing 5'11", Daniel Chen. Daniel is an associate in the Palo Alto office of Wilson Sonsini, where he focuses on privacy, cybersecurity, and data processing matters. Daniel is the go-to associate for DPAs in his office, and he feels good about his chances today on Battle of the Redlines. Daniel, the virtual cheers are deafening. They are so loud I can barely hear myself talk. So that's Daniel Chen. Our next panelist or contestant on Battle of the Redlines today, negotiating for the vendor and representing the scrappy startup, standing in at 5'2", Jessica Nguyen. Jessica is the award-winning GC of Lexion, the incredibly easy-to-use contract management system. Jessica is the former Startup GC of the Year winner and has tons of experience redlining contracts in her career. Jessica is no stranger to tough negotiations, and she is going to bring the thunder to today's Battle of the Redlines. All right, as the unofficial referee of this bout, I'm going to bring both of our contestants in the center of the ring. I want a good, clean negotiation, no name calling, no jokes below the belt, and I want you to provide lots of great tips and insights for our audience so that we can all benefit from your experience. And most importantly, and this is the #1 rule, let's have some fun. And with that, I'll turn things over to Jessica to get us started.
Thanks, Shai. That was pretty good, but thankfully you look real pretty today, though. So thanks for dressing up today, Shai. You look so dapper. So I heard, everyone, that there are over 2,000 registrants. So no pressure, Daniel. I know this is your first time doing a webinar. Or are you nervous or are you ready?
Not at all.
Oh, you're not nervous at all? I'm trying to get in your head and make you nervous. To prep, I did some bicep curls and some facial exercises. What did you do to prep?
Got a good night's sleep, took a nice long shower, drank way too much coffee. I'm ready to go.
So you did like normal things that are relevant to prepare for the webinar. All right, good job. All right, to be useful exercise for you, today, what we did in true large enterprise fashion, Daniel sent me a vague, one-sided, horrific DPA for me to review and redline. Thank you, Daniel. How much fun did you have making that?
Oh, it was fantastic. And my client's form.
Oh man, great work on that. It was horrific, and I had to do a lot of work to redline it. So thank you. I'm not really sure how I feel about that. All right, so DPA we have today, we actually have a Word document that we're going to go over, and we redlined it. And so we're going to talk through and negotiate the terms as if we were doing a real life negotiation. We're going to do some role playing here. And just a disclaimer, the DPA is going to be CCPA focused, and we're not going to talk about GDPR and standard contractual clauses. All right, Daniel, are you ready with that intro in mind?
I'm ready.
Okay, I'm going to get the Word file. I had to make a lot of red lines, full disclosure, because Daniel sent me such a horrific one-sided DPA. So to make the information easier to process, we're also going to swap between a clean view versus a red line view. All right, you ready to go, Daniel? You're going to start your little... Hi, Daniel. Thanks for joining me today to talk through the data processing addendum. How are you doing?
Yeah, doing well. Great to meet you, Jessica. Great to finally meet you in person. Looking forward to it.
Oh, great. Well, kind of virtually. I'm based in Seattle, Washington, as you can see from the Space Needle in my virtual background. Are you based in California?
I am. I'm in Palo Alto.
Yeah. Okay. Full disclosure, I did a little bit of LinkedIn stalking and I saw that you are based in California and you've been at Wilson Sonsini for what, 4.5 years, a little over 4 years?
Yeah, that's about right, but feels like a lifetime.
That's what I tell about what it's like to work at a hyper growth tech company. It feels like both a lifetime, but also no time at all because you're doing so many different things.
Yeah,
Well,
that's exactly right.
Oh my goodness. You also worked in-house at DocuSign. So that's correct, right? And so you have a little bit of in-house background as well.
Yeah. I did it backwards to most people. I went from in-house to the firm instead of the other way around. So yeah, a little bit of both.
Well, I have a ton of high regard for Wilson Sonsini. I actually have worked with your firm a ton. I've been a general counsel for a while. I actually know a couple partners really well here in the Seattle office. Do you know Craig Sherman and Manya Sachet?
I do, but I will say I'm not going to take that into account in negotiating this DPA.
Oh.
My client has very strong views on privacy, and I will say, Jessica, in most cases, my client doesn't accept any red lines to its DPA, but because you're a strategic vendor, we wanted to take this opportunity to hear you out and discuss any thoughts you had.
Yeah, I totally understand. I just wanted to let you know, that I love your firm and I have a ton of high regard for your firm and send a ton of business to your firm. So hopefully this negotiation goes really smoothly.
Yeah, and hopefully I still have a job after this.
You will, but it will remind me that I should grab lunch with Manya and Craig. I haven't seen them since before the pandemic because everything shut down. All right, so let's look over the DPA. So Daniel, in true legal fashion, I'm going to guess that your client, which is an internal counsel, didn't give you a ton of context because, well, they in turn didn't get a ton of context from their business client. Is that kind of what happened?
Yeah, that's right. I got an email last night telling me I needed to be on this negotiation this morning.
Well, at least they told you that we are a strategic vendor. I'm very flattered by that. To give you I thought it'd be helpful before we dive into the legal terms to just give you that context that I think would be so helpful to help you understand the nature of the deal, the nature of the risk, etc. Does that sound good, Daniel? All right.
Yeah, sounds good.
Great. So this is the DPA right now that has not been edited. Full disclosure, I did make a ton of edits, but in the beginning, Daniel, it really is more about giving you that context and setting the stage because as you know, that your client's DPA is super vague and not tailored to our services. Would you agree?
I don't agree. So it's a general DPA that our client uses with all its vendors. So,
okay.
Some of the terms are a little bit high level, but, this is our client's form. And, we do think it is market.
Okay, sounds great. Well, I'm just going to move on to talking about the product itself. So to give you some context, I think your client uses this based on my reading of the terms, not just for vendors or suppliers that are providing them services that will process consumer data in the B2C space. And so what I wanted to clarify with you, Daniel, is that my client, Scrappy Startup, we are a B2B SaaS provider. And unlike a lot of the other suppliers that you may have negotiated DPAs with on behalf of this client, we are not going to process consumer data. Like, Sephora, as an example, they just had a settlement. I think Wilson Sonsini did a blog post about it, that it was the first settlement about CCPA.
Yep, that's right.
You're going to know it better than I do. I'm in-house now. I don't actually like to read regulations and keep up with case law. Yes. So, when I see the blog post like that. Thank you, Wilson Sonsini, for summarizing that so well. It really shows me that the regulators are really focused on enforcement actions against companies that are processing consumer data, like the Sephoras or the Facebooks, Metas of the world, or even retailers. Is that your sense too, Daniel? I mean, you actually know this better than I do.
Yeah, that's what we're seeing. So regulators are going after kind of the bigger names first.
Well, good news for you as you think about the changes that I made, and I appreciate you presenting them to your client, is that we are not, well, as big of a name as a Sephora of the world. And then secondly, we're not processing and storing or reselling or somehow benefiting from consumer data. Just wanted to give you that context.
Yeah. I think in our view, appreciate that. In our view, you will be processing some personal information, right? I know the majority of the data that we'll be providing you, my understanding is contracts, approvals. So that will obviously include business contact information of the counterparties, right? And business and personal information of our own employees as well.
Fair enough. That is absolutely true. So let's walk through the red lines, but I just wanted to give you that context. And so what I did here, Daniel, as you'll see in the red line, is I provided some background for you to give you that context. All right. Let me know if you have any concerns about just adding an introduction or background clause.
This looks fine to me.
All right. I'm going to show you the original. So the other, really where I really added more substantive change is in the definition of big tech data and big tech enriched data. Do you want to share some, before I, show you the red line, do you want to share your client's positioning as to why this is the appropriate definition for this situation, or would you like to just walk through the red line?
Yeah, absolutely. I can explain our position. So completely understand this is CCPA, DPA. I did take a look at the MSA that's already been executed or finalized, and there aren't any privacy or data processing terms in there. Our position is, any data that we give to you, in addition to our CCPA obligations, these terms should apply to that data, right? Because there are usage rights and restrictions in here, data breach notification obligations, etc. So that's why the scope of the data subject to this DPA is all data and information that we provide to you.
Okay. Well, now that you have a bit more context about our services that you didn't get, unfortunately, from your client, and then they probably didn't forget from their clients, some other context is, the edits that I've made about our services is really because we are a multi-tenant hosted solution. And part of our proprietary IP is the data that we provide to your clients through our B2B SaaS provider, some analytics data that we in turn also share and provide to for the benefit of our other SaaS customers as well. So I just want to give you that clarity. So what you'll see in the edits, I know you'll need some time to process and consider it with your client, is that I'm excluding our proprietary IP data that we will in fact resell and use and give for the benefit of other customers, or ones that we provide to you through the service, even if it's not even based on your client's data. That may be the case as well, because our models and our IP is continually improving and learning. And we also have aggregated anonymized data sets to train some of our machine learning and AI models that will take snippets of your big tech data or big tech enriched data, but be converted into a format that is not intelligible to any human. It'll be converted, for example, I'm going to make this very concrete for you because I don't actually know what the words pseudo anonymization means and all those fancy privacy words. It doesn't make any sense to me because I'm a normal person with limited IQ, but to make it very tangible, we take information, let's just say like this clause here, personally identifiable information for your contract. Our machines convert that into numbers. Let's just say 1, 2, 3, 1, 2, 3, and they do some pattern recognition. We put that into a database to train the model. So every time they see the numbers 1, 2, 3, that is associated with a clause for personally identifiable information. Does this make you a little bit more comfortable with with this context and description in mind, Daniel? Does this make you more comfortable with the, significant edits that I had to make to protect Scrappy Startup's IP and a core part of its service? That is what your clients actually want to use as well for their business benefit.
Yeah, I think, Jessica, as an initial matter, our client's view is just given how sensitive this information and data we're giving to you, it's all our customer agreements, right? Our strategic partnership agreements, internal approvals, and how the positions we take and the thoughts that went behind those approvals and escalations. Our client does not want that data used for any purpose other than to actually providing the services to us. It doesn't want that data used to train your algorithms so that you
Okay.
can provide that to other customers. But I think, let me review these edits to the definition. Maybe let's move on to the substantive terms in the DPA.
Sounds great. I appreciate you escalating that back to your client. I will say your client is a very valued customer for us, for Scrappy Startup. We would love, us being a strategic vendor, you'd be a strategic customer for us. So if it makes your clients better, what we can do is do some engineering magic, meaning we can exclude certain data sets at this stage until your client is comfortable and wants to utilize and benefit from certain aspects of our cloud service that requires us to process their data in a certain way. How does that sound, Daniel? I know you need to escalate to your client. It's not really your Wilson Sonsini Senior external counsel decision.
Yeah, is to make sure I've got it right. Are you saying that if we don't permit you guys to use our data to train your algorithms, that certain features and functionality won't be available to our client?
I guess it depends on the data set that is excluded. So there's a couple things. Some you might be able to your client may be able to benefit from some. So what I would recommend is we go offline and talk about what your client, who has a better understanding than you, fair, because you're outside counsel, to be fair, about what data they are not comfortable with us processing, sharing, utilizing to improve our models or functionality. We can put it in a document. This is a large enough deal where I think that it's worth for us doing and map that out. There are some that we don't need, and your client can still benefit from the service. But I'm going to use our AI models as an example, because let's just say that we can run an OCR document and run our models over your contracts without having to actually train our models based on your client's customer agreements, as using your example. Okay. However, it's not going to get smarter because we're not using our database to train on your client's agreements. So it's really going to be based on the agreements that we've seen elsewhere through our other sources. So that's going to be less, but it may impact the quality of the output. So I just want to get your client to understand.
Understood, Jessica. I think our client's position is we're okay using our data to train the algorithm that's used for us, but we don't want that data being trained on algorithms used for other customers. And I think this is a conversation we can take offline and discuss for internal.
Yeah, totally fair enough. I honestly think that it's largely also a business call as well, but we can work with your clients to make them happy. All right, here's a big substantive change here. This is a section that is labeled Big Tech Data. Oh, where did it go? Here it is. And there's just two sections here saying about your data. What I added here is language to mirror our obligations as the vendor, the reps and warranties that we have, that we represent and warrant, that we have the right to share with you vendor-enriched data using your definitions. But what we're asking for in return is a similar rep and warranty, because really the data that's uploaded into our cloud solution is what your client choose to upload. We have no control over what data is being collected, how it's collected, what notices are being given, or even what is being uploaded. What are your any objections or thoughts into it? I know this is more red. Yeah. I know it's more red than your client may be able to see.
Yeah, absolutely. Can you scroll up a little bit? I think conceptually, my client can probably get comfortable with that. I think under 3A, I see you made an edit that says unless otherwise agreed to by the party, there are certain, unless otherwise agreed to by the parties in MSA, you've carved that out of the restrictions on what you can do with our data. I think in order for us to give that rep and warranty, we would need a little bit more clarity on what specifically you think is permitted under the MSA that you want to do with this data, other than providing us the services.
Yeah. So my understanding, based on a prior negotiation, to be fair to you, Daniel, it wasn't you that was the attorney that approved, or even the scenario, the business scenario that was approved at the time the MSA was negotiated. My goal in adding this red line was to make sure that at the time it was made decision to do business with each other and move forward, because this is a CCPA focused DPA. CCPA wasn't really fully fleshed out at the time the MSA was negotiated, that we honor the commercial and risk allocation that were agreed to in the MSA that was, frankly, heavily negotiated as well, Danielle. So to answer your specific question about what was permitted, absolutely, to deliver the service. At the time, the customer, your client, wanted us to be able to use snippets of the data to deliver some of the key functionality that I was describing to you, improving limited AI models that were, because we're not processing consumer data, they were okay with. Yes, there's customer agreements, but more of customer agreements about a business as opposed to about Daniel's buying habits or what ads, we should show to Daniel as an example. So those are the risks they were comfortable with at the time. I understand risk and needs evolve and change. So if you need to take that back to your client and talk to your internal clients, I understand that. Is that fair?
So it sounds like it goes back to the same issue we discussed before. If subject to my client's confirmation, if that's the case, I'm okay with that conceptually. I would just like to tweak this language. So instead of saying unless otherwise agreed to by the parties in the MSA, I think we can add language that vendors shall not use or otherwise process big tech data for any purpose other than the specific purpose of performing the services to big tech or as otherwise set forth or permitted in the MSA. I just don't want to give off the impression that, this is a restriction, you can't sell our data, right? But, unless we otherwise agree to an MSA. So
okay, yeah.
Just that, I would suggest that tweak in the language subject to, our businesses resolving the prior issue.
Thank you. I think that's a great compromise, Daniel. All right. Am I scrolling to the right place now?
Yep. So, subject to resolution of that, I think, we'll probably be okay with the language in B.
Okay, sounds great. What section should I scroll through next? I know that I'm the one that took the pen and I asked you not to.
So Jessica, I think I'd like to talk about 3D next. So previously we had a restriction, and it might help if we show the original language.
Yep.
So we had a restriction that you guys will not provide us any personally identifiable information. I see that you had some concerns and struck that language. From our point of view, I don't necessarily agree with the reasoning that, we should strike this because we control what big tech data is provided. As part of the services, we're giving you this data, and the services is we're getting back enriched and cleaned up data, right? So we actually don't have control over what data you give back. That is in your control, and we do not want any personally identifiable information, especially any personally identifiable information that may be enriched by you, right? We want to avoid any kind of perception that we're a data broker. So, for that reason, I think we should, we'll be reverting the language into.
Yeah, actually, as you talk that out, that makes a ton of sense. And I think we can compromise and work on that. The only scenario that I can think of, since we're a B2B provider, is that we can give you an audit history. So we give you an audit history of which individual logged in and what functionality and activity they've done in our solution. That will include PII because it will include the username of your users that you permit your client's user. So, but for that limited, is your client okay with us delivering an audit history, or does it want to turn off that function?
Yeah, I don't think that audit history would be big tech enriched data, right? Because big tech data is data that we give you.
Oh.
And big tech enriched data is data we get back that's processed using the data we give you, right? This sounds like data that you're generating. Audit logs is part of the services. So I don't think that falls within the big tech enriched data definition.
Okay, well, that gets me more comfortable with the risk. So we can re-add that back in, Daniel.
Okay, perfect.
Yeah. What were you thinking? I was just going to revert back to the red line.
Yeah, going down to 4. So I see you added in a clarification that vendors shall retain in all rights, title, interest into all vendor enriched data. I just want to clarify, because I can see a potential ambiguity in that you're giving us enriched data, our position is any data that you actually give to us as part of the services, so big tech enriched data, we should own all that because that's what we're paying for, right? If there's a copy of that information prior to it being put into big tech enriched data, we're fine with you retaining rights and ownership in that data. But our view is any output that we're paying for should be our data.
Okay. All right. We can make sure that's clear in the vendor enriched data definitions in the next iteration. Does that sound great?
It does. And then similarly at the end of section 4. So before, we wanted a rep and warranty that any enriched data that we get back, we can use it for whatever purposes we want, right? I see that you restricted to for the permitted purpose described in the MSA. The problem is, we don't know exactly what we may want to do with this data in the future. Is there a reason why, it needs to be the scope of what we can do with this data needs to be narrower?
I think in general, I just want to make sure that our scrappy startups, if it's something proprietary, if it's vendor enriched data, that we monetize and for the benefit of our other customers, that is not then taken by big tech, which has frankly more resources and a larger team than vendor, or in this case, scrappy startup, and then resold because you can use it for any purpose. That was my intent there. But if it's solely limited to, let me process back again, big tech enriched data and what that really means and whether or not there could be potential harm in our future business.
Yeah, understood. I think, definitely not the intent to be able to restrict, what you can or can't do with data that's not provided to us, right? I think in our view is if you have the same copy of data, if it's not actually provided to us and does not constitute big tech enriched data, we're not placing any restrictions on what you can and can't do with that data, right?
Right. I was just more making sure that if it could be data that more restrictions on big tech, not repurposing something that's proprietary to scrappy startup. Yeah.
So I think that kind of raises some concerns for me because, again, we're not getting any personal information back, right? So if there's personal information, I can totally understand the concern. So all of this data theoretically should be outside the scope of that. Are you saying that there are potential restrictions on what we can do with the data we're getting as part of the services? If that's the case, I think that's something we'll need to escalate.
So as based on the nature of the services, the intent was that your big tech client only use our service for its internal purpose. So, processing its commercial agreements, commercial documents for its internal purpose. The output that you can get from our solution, which has analytic capabilities, we may provide you insights as to in this industry and vertical, what is the most commonly negotiated clauses? Or here are the trends in this industry and elsewhere. We want to make sure that kind of output that is based on aggregated and anonymized data sets across all of our user base is not owned or can be used by big tech for their commercial purpose as opposed to their internal purpose.
Got it. So is a concern that if you give us industry trends, for example, and we turn around and just resell that as is?
Something like that kind of scenario.
I don't think that's the intent.
Okay.
How about as a compromise, we can restrict on what we do with the actual copy of big tech enriched data for our internal business purposes, but we're allowed to use for any business purpose, any data that we may derive from the copy of the big tech enriched data. So that way, if a part of your industry trend that you give us, gets incorporated into a broader industry trend report that we do want to sell, it won't be the exact copy of it, and it won't be the exact copy of what you give to us.
Yeah, so I think that sounds like a great compromise. And then the next round, what I'll do then is try to propose some language, and even to help you out, Daniel, since you are external counsel, provide some concrete examples as to map what you just said out, and some appropriate language around licensing and appropriate use rights. How does that sound?
Yep, that sounds good.
All right, where would you like to go to next? I know that
I see a lot of red in
Oh
section
no.
5.
Okay, so how about I make it less scary and make it go away?
So our position is we should have full visibility into whatever service providers or subcontractors that are used to process our data. And the concern here is, again, it's very highly sensitive information that we're giving to you. So we need to know what other third parties are getting access to that data, and we need to be able to control who has access. I think our biggest concern is it potentially falling into the hands of a competitor, right? Especially if you have, our customer contracts or partnership contracts, internal escalations and decision making. So that's why we need these terms.
And just out of curiosity, what are the nature of the competitors you are concerned about?
Yeah, so major competitor, we compete with Google, we compete with Salesforce,
Oh,
we compete
wow.
with a lot of big names in tech.
Man, big tech, you compete with all the big players. Okay, so I have a little bit of bad news and good news. Our intent here is, let me give you that before I jump into the good news and bad news. Here, let me just share the intent of the changes, the ton of changes that I made. I know it's a little scary and probably hard to process, but really because we're a hosted solution with hundreds, maybe even thousands of customers, that a multi-tenant host solution, we are a cloud-based service. We cannot agree to collect every individual client's permission before we engage a new provider. Honestly, Daniel, it just simply is not feasible or possible. We don't have the support to do it, the resources operationally to do it. So what I added here, Daniel, is very common language. You more often see them in GDPR or European data processing agreements and you'll see the terminology sub-processor versus what you've used here is subcontractors, is our process and positioning in terms of adding new subcontractors. I mirrored the exact same language. And what we've done to operationalize and scale is we will get, we fully clear to your client who we use as our subcontractors. In this case, we post it online. I'll include a link later, and why we use those vendors and for what purpose, including even, a link to their data processing terms. Do you compete with a little company called Amazon?
No, we don't view Amazon as a competitor, but we do view Google Cloud as a competitor.
Oh, well, I have some great news then. We don't use Google Cloud, but we do to process your personal data, your client's data. We do use AWS though. And so the bad news I have for you is, scrappy startup, it's unlikely that I can negotiate customized terms with AWS. So what I've done is link to their data processing terms in the page here. You smiled. I made you smile, Daniel. I'm so proud of myself. You're smiling. Have you negotiated with AWS?
No, I haven't.
Well, I have some insider knowledge. I have a ton of friends who work there in their legal team, and their general minimum threshold is millions of dollars. So sadly, we don't spend millions of dollars with AWS. But on the good side is we don't spend millions of dollars with AWS. So our COGS are very reasonable. Just some fun information for you.
Yeah, Jessica, understand your position that, the AWS of the world are not going to negotiate with you. I think, giving us a list of the current subcontractors that you think will be used is a reasonable compromise.
Okay.
We'll have to review that internally. The one issue I have with this is that I want to be clear that if there is a change, and assuming we're okay with the current list of subcontractors, if there is a change in subcontractors, we need notice prior to that change and essentially a veto right.
Okay.
Because again, if you want to change subcontractor and it's one that we have concerns with, including competitive concerns, we need to be able to essentially veto the use of that subcontractor.
Understood. In section B, you can make edits to it in terms of timeline. We do provide you that advance notice of any changes to subcontractors from the list that we published at the time this is signed. And there is a whole veto process that outlines your client's remedies. It could be, we can't use it, your client chooses not to use a particular service impacted by that subprocessor, or frankly, we just part ways. How does that sound?
Yeah, I think we'll take a look at this offline, but I think based on initial scan, we'll want to make it a little bit clear that this has to happen before the subcontractor is used, but we can review this offline.
Okay, fair enough. I'm going to go back to your
Then-
original. Yeah. So people, it was
Yeah.
really hard to read.
So, sticking with these subcontractors, it's our view that, that you should be responsible for any failures, any acts or omissions of subcontractors. I did see you had some language that narrowed this to, you should be liable for the subcontract compliance of any applicable obligations under this CCPA, DPA, or if the subcontractor causes you to breach any of your obligations under the CCPA, DPA. I think my concern here, Jessica, is, it's not very clear what our applicable obligations under the CCPA, DPA is. I think, there's room for argument. Our view is any breach of the CCPA, DPA by your subcontractor, you should be liable for. I think that's a pretty reasonable position. Let me know if you have any objections to that.
Okay. I think that sounds fine conceptually, but I would like to see the wording on it.
Okay.
Okay. What should we jump to next, Daniel, as you think is a material section to talk through? I know I made a lot of changes throughout.
Yeah, I think audit rights. So that's a key area for our client. I know you had made various
So let me
edits.
just the before. The before was this.
Yeah, so our client's view is, at any time we should be able to audit your security program, including those of your subcontractors.
Mm-hmm.
Do you have concerns with that?
A little bit. So here's the red lines that I made. So we completely understand the need to audit our security measures. And so what we've done is we've invested into getting SOC 2 Type 2 certification, which is a rigorous security audit process with best-in-class auditors. So what I am proposing, because again, earlier I said, Daniel, is that we have hundreds, maybe low thousands of customers support. We don't have the resources to allow each of those hundreds or thousands of customers come on and to conduct an individual audit. I'm going to be very honest with you, Daniel. Honestly, in my years of practice, I'm not going to tell you how long I've been practicing because we look the same age, even though I think, you might be a tad younger. You're smiling. I made you smile again. Is that none of them have actually exercised an on-site audit right. Fun fact, no one wants to do an audit because it's not as a part of their day job in terms of your clients. So what we've done though is I've added language to say, yes, upon request, we'll give you all the security info your client wants, it's like the security policies, etc. We'll provide you a copy of our audit reports. Today we have SOC 2 Type 2 certification. We're going to get ISO very soon. So we'll give you all information. And then if after all of that information, your client still thinks that an on-site audit is necessary, I've added some terms regarding the audit process and some guardrails there to make sure we have the resources and we're prepared to support your client in conducting that audit successfully. Next, and also to ensure that the audit and how it's conducted doesn't jeopardize the integrity and protection of the data of our other customers as well. I mean, we have these same guardrails in place for your big tech clients' data as well, because we want to make sure we don't lose that certification and lose the trust of our customers.
Okay, yeah, so I do see here you put in various guardrails, like we have to give you prior notice, you can't unreasonably disrupt your operations. I think conceptually, we can consider these edits. A few specific things I want to call out that will be marked up when you get the draft back is, so right now, if we think your audit reports are insufficient and we need additional information to comply with the CCPA, we're allowed to conduct additional audits. I think that's way too narrow. As you know, the CCPA contains very high level requirements when it comes to security, right? I think with this language, it's just way too narrow. And this is not just a concern driven by the CCPA. These are, general security concerns. So, if we believe that the information you provide is not sufficient, period, our security team needs to be able to conduct an audit. Secondly, I see here that, I see you're limiting the frequency of audits to every 12-month period. I think here, if there's a breach, if we find out about a breach of this DPA, or if you have a security incident relating to our data, we'll need to audit you sooner than 12 months, right? Yeah. So I think that's a reasonable carve out. And then separately, I see, we need at least 60 days prior written notice before conducting audit. Again, if there's a data breach, or if we know that you're in breach of this agreement, we can't wait 60 days. So I think, we'll be adding some carve outs, but let me know if you think any of that's objectionable.
No, that all sounds conceptually fine. So I look forward to seeing your changes there. That all sounds
okay.
Well. Basically, yeah, shortening and increasing audit period cadences. If there's a breach, I think that sounds really fair.
Got it. Okay. And Jessica, I think there were a few other key provisions I want to go through. I know this is scheduled for an hour and we're running short on time.
We are running short on time, so let's go to the meaty stuff.
Yeah.
Well,
I think it's section 9, security incidents.
Yes.
So I see before security incidents was defined to include any actual potential unauthorized processing of our data or any breach, security incident, et cetera, relating to any technology or system that you guys are using to provide us the services, right? First, I see you narrowed this. Just misuse, loss, destruction, disclosure, or unauthorized access is not sufficient, right? What have you guys stored in unauthorized matter? So we need to include any unauthorized processing of our data. And similarly, if there is a breach with respect to any technology that you're using or service you're using or system, we think that should be covered. And then I see here you also got rid of potential, unauthorized access to our data, for example. The reason we need that language is, in practice, a lot of security incidents aren't confirmed, right? Or it takes a long time to confirm. So any confirmed actual security incident we think is too narrow.
Okay.
As a compromise, how about we put any actual or reasonably suspected security incident? I think that probably addresses your concern, but let me know if you have a different view.
That generally addresses my concern. To give you some context on the edits there, I was trying to simplify the definition of security incident, because if there's any breach of the systems, that means that is processing your client's big tech data, then it's already covered by the former portion. But I'm happy to add the clarity back that this includes any breach of the systems and technology used in conjunction with delivering the services. That's fine. In terms of the potential language here, I like your compromise. The only clarification I would add is that potential excludes the unsuccessful attempts to penetrate. There's it happens probably 10 times every 5 minutes, unsuccessful attempts to penetrate the firewalls of our infrastructure. Otherwise your client's security team would get alerts every 5 minutes, and they don't want that. So I just want to make sure that unsuccessful penetrations are excluded from potential, the meaning of potential.
Yeah. The intent is definitely not to include unsuccessful. I'm sure my client security team does not want to get bombarded with those notifications. So I think if we change this to reasonably suspected, right, I think that should address your concern.
Okay.
The other kind of major concern I have with this is at the very end, our view is if there is any kind of security incident, you should be responsible for that. And it should not be subject to the liability cap. And we can discuss the liability cap or limitation of liability in section 10 later. Okay. But I see here that you've also limited to, you'll be only responsible for any penalties, costs, etc. in connection with a security incident to the extent the security incident is the fault of you or your subcontractors.
Yes.
In our view, one fault it's a kind of a squishy concept, right? If we give you our data and you guys lose it, or there's a compromise of that data, our view is you should be responsible, period, right? Yes. We don't want to get into an argument of whose fault it is, right? And secondly, I see here, you clarified a security incident shall not be considered a breach of your confidentiality obligations. Is there a reason for that? Because, in our view, all this data is confidential, right? So yeah, what's the thinking behind there? What's driving that?
Okay, so let me unpack that. There are two questions there, really, or concepts talked about there. In terms of fault, absolutely, I agree with you, Daniel, that if vendor or scrappy startup or any of our employees or subcontractors is loses your data or provides unauthorized access to your client's data, we should be responsible for the cost of the security incident. The scenario that I'm thinking about, given the breadth of the definition of security incident, is if one of the employees or admins of big tech decide to give their credentials out to an unauthorized individual to access the data stored in our system. That isn't our fault. Our systems wouldn't know that there's been an unauthorized access, especially if the IP addresses is not suspicious. So we just want to make sure that we're covered in those limited scenarios where in big tech's control, there is an unauthorized access, which is included in that scenario I just described. We're not on the hook for the cost of remediation of that security incident.
Got it. So how about this? What if we added language that says that carved out any security incidents caused by a direct act of our employee?
Yeah.
I
Okay.
think that should address your concern.
I'm always happy to add more illustration and examples in the contracts to make sure your clients are comfortable with taking on these exceptions as well.
Yeah, and to make sure we're on the same page, Jessica, that is in lieu of the language about fault, right? So instead of saying to the extent such security incident is a fault of vendor or any subcontractors, we would carve out any act directly caused by one of our employees.
Yes, we can do that. We can separate the concept. I'll try to think of some language, or maybe we can just define what fault means for this purpose.
Yeah, again, I want to get away from the concept of fault, but I think we're on the same page. We can propose some language.
Okay. Now, the second part of your question or topic was, why did I carve out a security incident is not a breach of a party's confidentiality obligations? That's because in the MSA, the parties agreed to carve out from the limitation of liability caps, a party's breach of confidentiality, but the intent of that carve out at the time of the MSA was negotiated was more of your standard confidentiality obligations of, that you see in probably every MSA or NDA. So that is the intent there, not to expand the breadth and scope of those carve-outs in the MSA unintentionally by agreeing to these terms, which may be interpreted as the same, but they're not the same. Data protection and security is different than scrappy startups saying, you know what, I know all this insider information about big tech. Let me share this with you, competitor, Google Cloud, that unlawfully. Does that make sense, Daniel?
It does. I get your position, but I think as a general matter, our view is any, breach of our data, any security incident we need indemnification for it. And also it needs to be carved out of liability cap, especially again, given the sensitivity we're getting, right? If our data were to get compromised, this would cause irreparable damage to our client.
Okay, well, I'll need to take that back. This is really negotiating a new commercial term. So I need to take this back to our executive team about assuming additional risk, Daniel, honestly.
Yeah. And on that point, Jessica, I'm not fully following the argument that it's a new commercial term, right? If the MSA had an explicit carve out for breach of confidentiality, I feel like actually we're explicitly clarifying that a breach of our data, which is our confidential information, is not a breach of confidentiality. I actually feel like that is reopening a settled issue. Right?
Yeah, I'm just sharing what was the intent of the carve out at the time the MSA was approved. I need to make sure that our client, the business side, understands if there's any expansion of what was understood, they need to understand those risks.
Yeah, understood. I think this is ultimately a business decision. I will say this is, a key issue for my client, and especially given that it was already agreed to, I don't think my client will have any wiggle room here.
Okay. While I know this is related, this is the indemnity and indemnification language. This is the before.
So Jessica, my client's view is just any breach of this CCPA or any security incident, we need to be indemnified for it, and it needs to be carved out of the liability cap. I see you've made various changes in here. Can you explain the concerns?
Yeah. So the first thing I did was to make the indemnity clause mutual. Again, I understand that the more likely scenario is that scrappy startup would be indemnifying big tech, But in the event, like the security incident scenario I described to you, that happens, or something is, or remember, big tech has control over what data how it's uploaded into our system and how it's collected and what notices are given. If for some reason big tech doesn't have the rights to upload the data into our system, and we are named in a claim or action as a result of big tech's action or something within its control, we should be indemnified for that. So that's sort of those limited scenarios we're seeking indemnity for. Is there any objection to that?
So the concern is if we give you our data and we don't have the right to give you that data, and the third party claim is brought against you. Okay, I think we can consider that. I would just want to make sure this language is tailored.
Okay.
So for my client, I think we can consider, accept as set or carve out that particular section. Does that work?
That works. And also,
Okay.
if it helps you sell this with your client, in the real world, I don't know if I was big tech, I would want scrappy startup and their own independent counsel interfering with my defense.
Yeah, understood. I think we can run that up. And Jessica, can you go up a little bit?
Sure.
I see here you've also, a little bit higher. I see here you've also limited indemnification to third party claims. That's something I'll need to run by my client, but understand the concern there.
I know, it's just a habit of mine. I really think the indemnity clause should be limited as a remedy for third party claim protection and not be used as a mechanism for first party claims. But that could be a whole nother, mock webinar that if you ever do one of those.
Yeah. I appreciate the concern. I'll just need to discuss that with my client. Here for part 2, the security incident, I see it's limited again to fault. Sorry, we go up to A.
Yes.
Yeah, so again, our position is, if any data, regardless of fault, if it's in your hand and there's a security incident, you should indemnify us for it. And I remember, I think the security incident definition, we've narrowed it to exclude any security incident that's caused by a direct action by one of our employees.
Agreed. So again, if the scope of the security incident, if we redefine security incident and the scoping, I can get comfortable with that, Daniel.
Yeah, I think here we'll also want to clarify, because I can see a situation where, to be candid, it was caused by an act of both of us.
Mm-hmm.
Right? Let's just say one of our employees accidentally gave out their credentials, but you didn't implement the appropriate security measures that should have stopped it. Mm-hmm. So I think we'll also want to clarify, carve out not just any security incident that was caused by an act of our client, but only to extent, the portion of the claim to extent caused by the act of one of our employees.
I really like that. And you're so articulate. Do you want to propose some language there on that?
Yep, that sounds
great.
Good. And then I think we can move down to C.
Okay.
So, again, my client's position is, any breach of this DPA, any security incident should be carved out from the liability cap. Jessica, I don't think we have any room on this. And, if you did want to negotiate this, I would have to run it up to my VP of finance, and she's on her annual vacation right now, and she won't be back till middle of January. So if you want to get this deal signed by end of year, that I'm not going to be able to get that approval or feedback by time. So, I'm happy to run it by her if you'd like, just based on my history of the client. I know they're not willing to budge on any carve-outs.
Yeah. So I understand your concerns. I know how it's vacation time, it's holiday time. Also, some clarity there too is I know that your clients are anxious to sign by the end of the year as well, though, because they're going to lose their budget, and they're really, because of the macroeconomic climate, they're really afraid they're not going to get budget approval for 2023. So I think both of us are really motivated to get this done by year end. Here's what I'll do. I'm going to actually escalate this issue to see if I can get a super cap for you to our CEO. And see what we can do there. Hold on. Can I just go on mute for a second?
Yep.
All right. So our CEO Gaurav has given me to give you a 2x super cap on what we've already agreed to in the MSA. And my ask is you bring it to your client. If it's a no, I totally understand, but there's pressures on both sides because your client may lose budget.
Yeah. So 2x. So my understanding is we contemplate about $1 million per year, for a period of 3 years under this engagement. 2x that is only $2 million. Again, given the sensitivity of the data that we're giving you, right? This is all our customer contracts, all our partner contracts, how we make decisions internally. I'm happy to bring it to my VP of finance, but I can tell you just based on experience, this isn't going to be anywhere remotely close to what we need.
Okay.
Jessica, just so I want to find a compromise solution, right, and get this done. How much coverage do you have under your cybersecurity insurance?
It is actually spelled out, and we have about 10 million. I believe some, let me double check, 10 million today. And then we also have umbrella coverage. However, it is not our position to scope any sort of liability caps based on our insurance coverage. That's still, any sort of super cap still needs to go up to our CEO, honestly.
Got it. I understand. I'm just, I just know if we go back with $2 million, that's a non-starter. Candidly, I think even $10 million is going to be a non-starter for my client. So I think, this is ultimately a business decision. Can you maybe talk to your CEO and then get back to me, and then I can escalate it if you want to pursue that?
Yeah, will do.
Okay, great. So now we're a little bit over. Those were the key issues that I wanted to discuss. I know there were some other more minor issues, but we can probably just address that offline via Redlines.
Okay. Well, thank you for taking the time to chat with me before the year. And I know it's super busy. And thank you for reminding me that I need to grab lunch with my Wilson Sonsini partner pals.
Absolutely. Thanks for taking the time.
All right. Bye. And scene. Shy. We're done.
You're getting real claps from me. You deserve virtual claps from the rest of the audience. Here is the results. And sorry, Jessica's luckily there's a lot of space between us, and you're not going to be able to beat me up for that third option that I snuck.
No, there's no participation trophy, Shy. No.
And for the people on the line, I think this isn't the end of the presentation. We're going to be going through a summary of some key terms and giving an overview of why we push for certain things, and some things that we think are market or good fallback positions. So stick around until after the poll.
Awesome. So I have a lot of great things to talk about in Q&A, and shout out to everybody who's participating, who's active in the chat, super active chat. We're going to take this chat, clean it up, and post it because so many people have been asking for a copy of the chat. So rest assured it will be there. I guess, Dan, and Jessica, do you want to talk about these takeaway points and the rationale?
Let's do the takeaway points.
Okay. Awesome.
Next, we're going to be going through some key stuff and trying to give you our thoughts on how to approach these issues when you're negotiating these contracts. So I think the first thing is, what is an appropriate definition and scope of data and data processing rights? Privacy laws obviously cover personal information or personal data. That in practice, if you're negotiating this, you want to also cover just all data and information, right? So as the customer, you should restrict on what the vendor does with any data and information you provide with them. It should be covered by data breach notification and remediation requirements and related requirements. So this is really a push and pull. It also depends on what you have in the MSA. So a lot of times, MSA might have data processing rights and restrictions. In that case, it might be okay to limit what's in the DPA to personal information. So that's one thing to keep in mind. The other thing that we commonly see is the DPA not really working or taking into account the MSA. So we frequently see, for example, the DPA just using personal information as a defined term and defining that as what's set forth under the CCPA or personal data as it's defined under the GDPR, right? So there, you just want to make sure the term actually works with the MSA, right? Because that definition by itself, personal information, it's not appropriately clear whose personal information is that, right? Is that personal information that we provided in the context of agreement? So that's something to keep in mind while you're drafting. Notice and consent obligations. This is something that Jessica pushed for, and I think is absolutely right. As the vendor, if your customer is giving you data, it's key that you have some kind of contractual protection that your customer has the ability and the right to give you that data. On the flip side, if you're the customer, a frequently overlooked issue is if you're getting data from the vendor, you should similarly get some kind of contractual protection that the vendor actually has the right to give you that data and for you to use it for how you intend it, right? So that was a point that Jessica and I negotiated in this mock negotiation. Next, for data breaches, we commonly see people trying to limit data breaches to what the GDPR definition, for example, or even worse, what a data breach is under US laws. US laws in particular, what triggers data breach notification requirements under US laws in particular is extremely narrow. And again, I think it's very reasonable that if a vendor, loses any of your data or information, they should notify you, they should address it, etc. I think this is a frequently fought over issue about cost. So if a data breach happens, who's actually responsible for the cost, right? So here, the vendor agreed to be solely responsible for any penalties, costs, or expenses incurred by big tech in connection with a security incident. One issue to be mindful of is putting guardrails on any kind of cost allocations, right? So if you're the vendor, you want guardrails about reasonability, for example, right? So you should only be on the hook for reasonable costs that your customer incurs, right? So let's just say there's a minor data breach. Your customer goes and hires 2 different forensic investigators, hires the best law firm and the most expensive law firm it could find. And then all of a sudden, instead of being on the hook for maybe $50,000 of fees, you're on the hook for $500,000, right? So that's something to keep in mind. Another common issue we see is not limiting to costs that the customer is actually required by law to incur. And in practice, what we see is, customers providing credit monitoring, for example, when there was no financial account information, no identity documents that were compromised. It's become one of those things where it just looks good to give people, identity protection. So, and you don't want to be on the hook for something that, the customer didn't even need to provide. I think moving on to service provider, I think Jessica did a great job here. We're still frequently seeing contractual requirements that you impose all these, get specific terms in your contract with service providers, that you require service providers to allow audits, right? In practice, that just doesn't work. Good luck getting AWS to agree to that. Right? Let's see, we most times, if you explain that, we find you'll be successful in getting that removed. If not, I think a good compromise is to carve out generally available commercial products and services from those requirements. So I think most people understand, again, you're not going to get AWS to agree to your terms, right?
I normally carve out too, just to jump in, is specific consultants that are engaged to deliver a project for that client. So if I'm going to engage ABC client to help with the implementation of our SaaS, that's different than AWS. So that's another clarification I agree to all the time, Daniel.
Yep, perfect. I think we go next slide, audit rights. Here, I had pushed for extremely broad audit rights without any guardrails that also extended to Jessica's service providers, right? Again, I think Jessica rightly told me to go pound sand.
Say pound sand, but kind of
in a much nicer way. And Jessica pushed for a lot of really key and practical guardrails, right? Prior notice, limiting the frequency in which you can audit. Audits must be, reasonable in scope and duration. It must be subject to your internal policies and procedures and obligations to confidentiality. Less common guardrails that, we typically try to push for is just clarification that any audits won't involve your production environment. I know that seems like common sense, but you'd be surprised at the frequency we get pushback. And if your customers do intend to, do pen testing on your production environment, you should get ahead of that and nip that in the bud in the negotiation stage, as opposed to down the road. Let's see, other kind of less common guardrails that we would put in place are, if a customer does conduct an audit, they need to share the results of that audit with you. Once in a while, we'll see a company, especially if they're going through an acquisition, for example, and the buyer knows that there was an audit by a material or key customer, but then the vendor or the target, has no idea what the results of that audit was. Has no report, doesn't even know the results. So that's something you want to avoid. And also requiring the customer to consult with you and review the results and give you an opportunity to kind of comment on the results before it gets finalized. So a lot of times, your customer or one of their third-party service providers, they don't have intimate knowledge of how your systems work, your business works. They might mischaracterize something as high risk when in reality, it's not material. Or they might identify false positives that are just not risk based on how your systems are set up or how your business is run. Let's see, kind of probably the most meatiest one, indemnification and liability cap. So what to cover? If I'm the customer, as you saw, I want everything covered, right? That's for indemnification and also carve out the liability cap. If I'm the vendor, I think Jessica pushed for the key thing is the right to give the vendor that data, right? And this is especially important in certain contexts, in certain high-risk contexts, like if there's biometrics information involved, right? So if I'm the customer, in terms of what's critical, if I could only have one thing, I would probably push for breaches of confidentiality, because you think about in practice, the practical risk usually comes up if there is a data breach, right? And breaches of confidentiality, if I can only have one thing, although not ideal, should theoretically cover that, and also misuse of data. A quick note on first-party versus third-party claims. This is something that we tried to highlight in the negotiation, but I'm frequently seeing more and more first-party indemnification obligations. So they're typically drafted as, one party will indemnify the other party for any claim, litigation, etc., right? Indemnification obligations should be limited third-party indemnification. There's really no good justification for first-party indemnification, and it just removes a lot of the built-in efficiencies that you otherwise would have. Right? Yeah. So if I know, me as a customer, if I know the vendor needs to be on the hook for any fees I incur in connection with a claim that I bring up against Jessica, right? Like that removes incentive for me to be efficient, right? Instead of hiring, a reasonable law firm, I'm going to go get the best litigator I possibly could, right?
Yeah.
Similarly, if it's, if I suffer immaterial damage, let's say it's $25,000, normally that wouldn't be worth it for me to go and get a litigator and go down that path. Instead, I would probably incentivize to negotiate with Jessica for example, a fee credit, right? Or a discount. It just removes all those built-in incentives. So that's a key thing to look out for. And that's something we're actually unfortunately seeing more and more of, people trying to push for first-party indemnity. And again, there's really no good argument for that.
A couple points of clarification is that, it's hard to negotiate these agreements in silo. Totally acknowledge that. There's always an MSA in play that's been negotiated. In the real world, when you're negotiating an MSA with big tech, large enterprise, they're often going to ask you to spell out or have certain insurance requirements that are going to be disclosed there. So I answered as if I was negotiating with the Microsofts and the Googles of the world, who are going to have insurance requirements and oftentimes be asked to be an additional insured. So no secret there, not going to hide the ball. The second thing I wanted to say was oftentimes in my indemnity clauses that I negotiate in MSA, I'm very clear about if you're going to tender a claim for indemnity, what the process is, who has control over the hiring of counsel, settlement negotiations, etc. And if the indemnified party wants to be involved, you can get counsel of your own choice and don't hire a ridiculously expensive one who may not even be that effective. So that's my only add. Go ahead, Daniel.
Yeah, no, that's all exactly right. In terms of liability cap and amount, what's market really depends on the nature of the services, the industry, and candidly how much leverage you have most of the time, right? Yeah. It's very common if you have a big customer that will be the point that they just don't budge on and you just need to eat. Ultimately, it's just a business decision, right? Mm-hmm. As a starting point, I would say across the board, it's still fairly common to see cap at what the fees paid in the prior 12 months. I think that's still, middle of the road. If I'm the customer, though, I of course ideally want uncapped. And you should keep in mind about the potential damages you may suffer, like in this mock negotiation, right? The vendor has all of our contracts, all of our internal decision-making information, right? If that were to leak, $1 million or $2 million would not be enough, right? So keep that in mind. In terms of fallbacks, super caps at a multiple of what was paid in the 12 months are common, right? 3x, 6x, 12x, 20x. again, this is just ultimately a business decision. One thing I want to point out is, capping your liability at your insurance coverage. And this is something that Jessica pushed back on. And I think it's exactly right. Because, I see this more and more common. The thinking is, well, if I have coverage for, let's say, $10 million or $5 million on my insurance policy, if I agree to the liability cap of $5 million, that's not really a big issue because all I'm on the hook for is the deductible, right? But in reality, insurers will do absolutely everything they can to not pay out, right? So it is extremely hard to get an insurer to pay out under the policy. And even if they did pay out, you've just exhausted your entire insurance coverage on one customer, right? That's something to keep in mind. Another thing to keep in mind when you're the customer side is, do you think the vendor even has the ability to pay, right? If the vendor agrees to uncapped liability, or the vendor agrees to, let's say, a 10 million, 20 million super cap, right? If it's a startup, that will probably bankrupt the startup, right? So I think that's something that needs to be taken into account in the decision-making process of whether or not we should even engage this vendor, and something that's often overlooked. So, just wanted to flag that.
Hey, on behalf of Scrappy Startup, well, actually, by the time Daniel is engaged in the process, the reality is it's the end of the sales cycle. The business has done their vetting of the various tools and solutions and has chosen this solution because it fit their particular business need. And it's not a legal call, which, that's what the situation. In terms of resourcing, I agree with Daniel's, a lot of startups will just be like, sure, uncapped liability, who cares? You go after me. I don't have any money anyway. I don't have any, I'm not even profitable. So good luck collecting. So for a large enterprise, they're going to just have insurance requirements generically, and then are often going to have their own insurance. Large enterprises like the Googles of the world and the Microsofts, I worked at Microsoft, they're self-insured. They make 100 billion plus in revenue a year. They don't need insurance. Or they have their own insurance if there's any sort of breach caused by any of their vendors. So that is what happens in the real world. If the business has made a decision to work with the startup again, startups have their pros, maybe less profitability, but more agility and a better product.
This is probably on a lot of people's minds right now, the CPRA that's coming into effect in a few weeks. And so for those that don't know, the CPRA, the California Privacy Rights Act, is coming into effect in January 1st of 2023. We were supposed to have regulations finalized that clarify aspects of law and provide guidance. Those have not been finalized yet, despite the law going into effect next month. Relevant to DPAs is, people are going to need to update their CCPA DPAs to include CPRA specific terms. And in addition to the CPRA, we have various other states that have privacy laws that are coming into effect next year as well, right? So, and those laws will also require terms to be put in place with your service providers. The difficult part is a lot of these laws use different terminology. So it's going to be kind of tricky to balance and have something coherent that makes sense, that satisfies all these laws. But that's just something we wanted to flag. And those other states are Colorado, Connecticut, Utah, Virginia. So in addition to California, you have to worry about other state laws. Yeah, I think that's everything we wanted to flag.
Well, thank you, Daniel, for that great recap summary. Wow, Shai, the aviators are back on.
That's it. My Michael Buffer impression has resumed, and that's because I'm going to announce who actually won this battle of the Redlines. Drum roll, please. The winner is by 4 votes. Are you ready? Are you ready? Daniel!
Oh, Daniel won. Oh, man, I'm going to hear it from everybody.
4 votes? Wow.
4 votes. 4 votes. I was the ref. It was a good, clean battle. It was respectful, insightful, engaging. Everybody right? The real winners are In-House Connect's audience and everybody who got to watch. So everybody leaves a winner. We are in participation trophy land, firmly within participation trophy land. But anyways, I digress. Thank you, Jessica and Dan, one more time. Thank you, Lexion. Thank you, Wilson Cincini, for lending us one of your best and brightest associates. And this was wonderful. Thank you, everybody, for tuning in and participating.